Actually, we're on State of Washington versus Sabra K. Danielson, 576-759. Proceed.
Thank you, Your Honor. Good afternoon. My name is Willa Osborne with the Washington Appellate Project, representing Ms. Sabra Danielson. The Supreme Court in Blake ruled that our simple drug possession statute unconstitutionally criminalized and punished innocent and passive conduct. And in that decision, the court acknowledged the hefty fines collected by the state wrongfully from people like Ms. Danielson. And our legislature responded. It set aside millions of dollars with the express purpose to create an aid pool to assist counties that were obligated to vacate Blake convictions and refund LFOs. 7.8 motions are the exclusive remedy for seeking a Blake refund. And that's exactly what Ms. Danielson did, like thousands of others. But when the court vacated her conviction, it issued only a partial refund. The state cannot choose whether or not to refund legal financial obligations depending on the method of payment it received. Ms. Danielson is entitled to reimbursement whether she paid her debt in cash or check or by credit card, or in this case, in community service work valued at a minimum wage rate. These refunds, by the way, are not damages. The United States Supreme Court in Nelson v. Colorado said when a conviction is invalidated, the presumption of innocence reattaches, and the state is then obligated to refund those fees exacted from the defendant with nothing more than minimal procedures. The court that modified Ms. Danielson's method of LFO payment did so because she is indigent. It allowed her to pay her debt with community service labor valued at a minimum wage rate, no different than if she had paid her LFOs with wages from her employer.
Okay, counsel, I'm sorry
Yes.
to interrupt, but what relevance, if any, is it that if she had had cash to pay, it would have gone to the state or probably the clerk's office?
Sure.
Whereas when she did her community service, there was no receipt of that value by the state or the clerk's office. It was to some charitable organization, as I understand. Why is that not a difference? You say there's no difference. Why is that not a difference?
Well, I think there's a difference because when you look at the language of the statute that empowered the court to convert her LFO payment method, it also authorized the court to waive part or all of those LFO payments or to modify the method of payment. And those words are meaningful. She performed labor that was received by the state as payment at a rate established by the legislature and collected by the state as such. And I think that's the meaningful difference. I think it's also meaningful by analogy to restitution principles, which, by the way, I think are valuable only by analogy because we're, again, not talking about damages. But in the context of restitution, we look for easily ascertainable amounts. And here we have that from the legislature. We have that in RCW 10.01-160, subsection 4, which establishes that community service work performed by someone like Ms. Danielson is received at a rate, not remitted, not waived, but paid and received in that effect. Does that answer Your Honor's question? So. I'll continue. This withholding of this portion of her LFO payment implicates equal protection. And it does so because when the state treats similarly situated people differently with respect to an important right or a suspect or semi-suspect class, there's an equal protection violation unless the state's objectives are legitimate and important, and if there's a direct and substantial relationship between its objective and the means employed. And there are two reasons why that intermediate scrutiny is important here. The first is because this right to the presumption of innocence is at least an important right, if not a fundamental right. And secondly, our Supreme Court has already determined that when a classification is based on indigence, we apply this heightened level of scrutiny. That level of scrutiny also requires the state to set forth its genuine reason for its objective, not post hoc and not in response to litigation. And significantly here, the state has offered no objective that is absent from the state's briefing, and that's meaningful. Even if we apply a rational basis, this court's decision in Ray Stevens, also looking at Rainier v. Smith, Willoughby versus the Department of Labor, these are rational basis cases where the court determined administrative convenience, administrative tradition or practice, and even the preservation of state funds are not sufficient rational bases to defeat an equal protection claim when we're looking at discrimination on the basis of wealth.
So counsel, there's a line of equal protection and substantive due process cases, though, that talk about economic line drawing, and the basics are that the state has a limited pot of money and that the legislature can make judgments about how it wants to spend its money. And so we give a lot of deference to those kinds of judgments. So help me understand why that's not this case, why it's not a matter of limited state funds and the determination that there's going to be an expenditure of limited county or state funds in a way that's reasonable. And while we may make a different judgment call if it were us making the decision, that the state and the county are entitled to do that.
Sure. Well, I think the balancing test that the U.S. Supreme Court does in Nelson versus Colorado is instructive. And I can find possibly a direct quote and share that in reply. But part of the procedural due process issue there was that these amounts that a defendant whose conviction is invalidated is entitled to have returned to them are often so small, in this case, $110. The cost of erecting a procedure by which someone like Ms. Danielson would need to hire private counsel and pursue some civil damages claim would really be a procedural due process issue.
So yeah, but we're talking about equal protection, right? And we're talking about rational basis review, which is not what was happening in Nelson. That was a Matthews v. Eldridge analysis. So when we're squarely in that rational basis review, why should we not be looking towards those economic cases that give rational basis sort of deferent, really strong rational basis deference to that determination of how we're going to spend county and state funds, or how decision makers in the executive and other branches, or that our county decision makers are going to make those decisions?
Yeah, we'll see if I can find authority while the state speaks to that point. But I do think there's a real problem with affording the courts to discriminate between individuals who did make payment. This is not a request for a refund for community service work performed in lieu of jail time. There was a real conversion of this time, these hours, to a monetary rate. Our legislature has expressly funded the return of these fees collected for passive, innocent conduct. And I believe whether we're looking at procedural, substantive due process, and also equal protection, it is a problem for the state to withhold fees and erect a more substantive procedural burden for individuals who were too poor to pay in cash. And I'll address your additional questions.
Thank you, Council.
Thank you so much.
So I'm Jesse Espinoza, Deputy Prosecuting Attorney for Clallam County, State of Washington. This is a case where Ms. Danielson was ordered to do 30 days of jail for violating a statute that was lawful at the time. Those 30 days were converted to 240 hours of community service work. So she did those hours, and the court monitored it. She did more than that. And so when it came time to account for the community service work, the court noted that there was more than required. There was excess. So the court converted those to apply towards the legal financial obligations. There was no order. After that, there was no order. And Ms. Danielson continued to do community service work on her own accord. And the court continued to grant credit for that towards legal financial obligations. So the reason I mention that is because what we're talking about, equal protections, and the cases cited by the appellant, a lot of those cases dealt with somebody who was actually incarcerated. They were facing imminent incarceration or under order to do incarceration for, et cetera, not paying their LFOs.
So why does that matter for purposes of sort of equal protection line drawing? I mean, I think the argument is you can't treat someone who paid cash differently from someone who paid with work. So why does help me understand why the insertion of a court order matters when we're doing that equal protection balancing?
So the appellant's asking for intermediate scrutiny.
Right.
And in those cases that were cited, they were all faced with incarceration because, for one, there was no order, which the appellant says there mentions that there was, that they had to do community service work under threat of incarceration.
Okay.
There was no order. There was no threat of incarceration. Additionally, there was no cite to any authority that a person could be incarcerated for a non-willful payment of legal financial obligations.
So she wasn't forced to perform the work to pay off the LFOs, and so that, in your mind, is the operative fact.
That's one of them, and
Okay.
the fact that she could not even be incarcerated for being poor and not paying her LFOs. The only way to do that, to incarcerate somebody that way, is it's got to be willful. So as long as somebody is poor and cannot pay the LFOs, the court cannot incarcerate her, period. So she's not facing incarceration. This is not equivalent to the cases that call for intermediate scrutiny. And so now there's the request to get this money back for community service work based on some people got the money back because they could afford to pay them, and those that didn't pay LFOs did community service work. The problem with that is there are no facts showing that this class was based on economic status. You, as somebody who maybe is middle class, they can still have a financial hardship. A manifest hardship is what the statute allows for. So you could be somebody who has more resources and still opts to do community service work. You can be somebody with less resources and still make your LFO payments. And that kind of happened in this case to a certain point. So the classification is not, it's not really, it really is not there. There's not a distinction or discrimination based on economic status. Now, if somebody did community service work and say 2 hypothetical classes that did community service work, and some were given a refund, or not a refund, but given compensation for that community service work, and others were not, and if it was based on economic status, that could be a problem. But that's not something that happened here. So I don't believe that the appellant has established a class showing that they were treated differently than others in the same class. And certainly the court's decision had nothing to do with the person's economic status. The court was going based on the authority that it had, looking at Nelson, looking at Hedge, and those cases show that there was no reward for doing community service work. The only thing that those cases gave back was what was actually paid. And now we go back to the legislative action of the general fund. And for one, it is a general fund. It is not a statutory directive of how to spend those funds. It is not an implied waiver of sovereign immunity, because it does not say you must pay these funds for this purpose or that purpose or this purpose. There is no express provision and no way to read it in to a legislative setting aside of money to assist the counties. There's nothing there that says that you have to pay this for community service work. And even the case cited by the appellant, Union Elevator and Warehouse, that's an interesting case because there was an implied court, a statement by the Supreme Court that there could be an implied waiver under certain conditions of a contract or if the language of the statute permitted. And in that case where the company had to move its grain elevator because they were doing a highway project, ultimately the court said, yes, the Relocation Act, you can recover from that. No, it does not give you interest for those 7 years you were waiting for recovery, because the statute does not permit it. So it is not an implied waiver of sovereign immunity. It's not simply, well, if we can think it up, or if it's just, or whether we think you should have it. It still goes by the basis, the language of the statute.
So counsel, if we agree with Division 1 that 7.8 is the exclusive means of obtaining these refunds, is sovereign immunity still an issue, or is that only an issue if we, in our minds, think of it as a civil claim or a civil proceeding?
Right. So I do believe sovereign immunity certainly applies to all of this. And that's why we don't have any case law where somebody is given monetary damages for after one of their convictions is voided. That's been the way of the law of the land for ever since we've been here. That's why we had to have, I think in the 60s, where they've recourse for the wrongfully convicted. Because even before that, the wrongfully convicted could not be compensated for their time, community service work, or payment of LFOs, whatever. So it wasn't until we had the wrongful conviction statutes that did create a waiver, but even that is limited, and you have to establish that you were wrongfully convicted. And there's a definition for that in the statute.
Yeah, but those are all civil, like ultimately civil cases for damages, right?
Yes.
Yeah. So a claim under 7.8 is something sort of, it's just a different animal.
Right. So 7.8 is a collateral attack, and that's where In re Williams comes in, because what that points out is that a claim for money damages is not collateral, it's not attacking the judgment and sentence. Therefore, a claim for money damages is not appropriate under CR 7.8 action, which is what this was. And there's plenty of case law, whether you want to call it a personal restraint petition, motion to vacate, collateral attack, it is all under the same umbrella. We do have case law to that effect, and if the court wants additional authorities for that, I'll be happy to provide it. So in this case, this is a request for money. It's not, now the motion to vacate was an attack on the judgment and sentence, and rightfully so. The provision of LFOs already paid, that is well established under case law. That follows from the motion to vacate. It is not a claim of its own. The money for community service work is simply a request for money. It doesn't belong in a motion to vacate. And I think that Ray Williams makes that very clear. There were a couple holdings in that case. Initially, the court held that the Superior Court was wrong by treating this civil motion for damages as a 7.8 and transferring it to the Court of Appeals. And then it was the Court of Appeals error as continuing to treat it as a personal restraint petition. And it was sent back, remanded, and with the command to treat this as a civil action, because that's what it is. So I still have time. I'm going to address some of the issues raised during the first portion of the appellant's argument. And one of them is about the statute. And what the statute is, I don't know if it was cited or not, but it's RCW 10.01.160, subsection 4. It's been around for a while, and it allows the defendant to petition. It's not a product of a court order ordering somebody to do community service work. The defendant is given the opportunity to petition because if they're experiencing a hardship. And so it permits the court, it's permissive, to grant some form of relief, whether it be modifying the payment amounts, modifying when the payments are made, or even now expressly permitting community service work. And so this is a one-way street. It doesn't permit converting it back. It is a way for somebody to avoid having to pay by doing community service work. And as pointed out earlier, community service work is not something that the state banks. The state is not able to say, well, because you're doing community service work, now we don't have to have such and such employee do this work, or have such and such contractor do this work. The state doesn't get the benefit. The benefit is to the defendant to not have to pay LFOs. And to be able to use that against the state later, now that a conviction is vacated, that is exactly why there is sovereign immunity. Because the state has to be able to regulate its affairs, to be able to avoid a multitude of claims for money, especially when they've made a statute that is there to benefit somebody who's been convicted of a crime. So the remedy that is being sought is kind of, I think, a little harsh in that respect, and cuts against the point of why we have this statute, to allow somebody, by legislative grace, to not have to pay legal financial obligations. As far as the claim about the restitution and how the trial court misinterpreted restitution, because restitution includes property and services, which could be community service work. The problem with that argument is that restitution, again, is a civil remedy. It's not something that could be brought in a 7.8 motion. And even in State v. Hecht, the court pointed out that even though there is this restitution request, it's a civil remedy, and the court was not willing to give monetary compensation for community service work that was done. So we don't have any authority that's been provided for why community service work should be a way to get monetary compensation. This is not the first time a case has overturned a statute as being unconstitutional. There have been other statutes, whether it's harassment statutes or firearm statutes, and there are a multitude of cases where people do community service work for whatever reason or other, and yet we still don't have a case that says, we're going to give you money for doing community service work. So I think that the sovereign immunity and the appropriateness of the claim in a CRR 7.8 motion, there's no due process right to compensation for community service work. I am asking the court to affirm the lower court.
Thank you.
So I'd like to briefly start with addressing the question regarding discrimination on the basis of indigence and the equal protection issue. First of all, I'm looking at Willoughby versus the Department of Labor and Industries. There's language in that case, and I'm quoting here, but I don't have the pin site. Preservation of state funds is not a sufficient ground to defeat an equal protection challenge, and that was under rational basis. I think it's also meaningful looking toward petition of Fogel. The classification was not specifically indigence, and the state spoke about the hypothetical defendant who is not constitutionally indigent, but who petitions the court for modification of payment based on manifest hardship. And I think even that does not disturb what should be the holding of this court, because wealth-based discrimination runs afoul of equal protection, regardless of whether someone is established as indigent or simply doesn't have the means to pay. And then I would like to turn to what the court did in this case. And that is to rely on the wrong rule. RAP 12.8 plainly doesn't control what Criminal Rule 7.8 authorizes, and it applied the wrong case law. It held that RAP 12.8 and State v. Hecht controlled, but Hecht's application is frankly unhelpful. At the time that he was petitioning for damages in excess of $1 million, he had already received compensation for the legal financial obligations he paid pursuant to his conviction. And what he was seeking was a refund, a dollar amount for his lost wages and community service work performed in lieu of jail time, not damages that were paid in satisfaction of his judgment, as were the dollar amounts received by the court by Ms. Danielson in performance of her community service work. I also want to return to In re Williams, which the state spoke about pretty extensively, and I think the facts there are important. And they're important because Mr. Williams was seeking $300,000 from the Department of Corrections relating to claims that he was unfairly ordered into his cell and that he missed dinner, and that he didn't get a job in the prison kitchen. These are clearly claims for damages and clearly outside the purview of a 7.8 motion, seeking $110 for money actually received by the court, by the state, at a value of $7.16 per hour. If the court doesn't have any additional questions, I would ask that this court remand with instructions to the court below to issue a full refund to Ms. Danielson, as it has done 1,000 other petitioners in their 7.8 motions for payments pursuant to an unconstitutional and void conviction. I thank you for your time.
Thank you, counsel. We can proceed with our third case this afternoon, set for 2:30.